How can you defend someone you know to be guilty is probably the question I get asked the most when people find out that I work as a criminal defence solicitor. Hi, it's Ben Darby again from Darby and Darby Solicitors, and welcome to my short vlog about access to criminal defence services and defending yourself either at court or in the police station. Now, to answer that question first is how can you defend someone you know to be guilty? The answer to that is I don't. The reality is when you find solicitors representing defendants in court, what they are doing is putting across another side of the story, and that's the defendant's side of the story. And if, for example, I'm representing someone who's been involved in a fight on the harbour side, there's usually an account given by the defendant, well, I was acting in self-defence, or it wasn't me. And that's why you will find defence solicitors, including myself, are not defending people when they know they're to be guilty, because in fact what they're doing is putting across a different account, a different side of the story. Now, don't get me wrong, there are times when the evidence against a client is overwhelming, and it's part of our duty to tell that client the evidence against you is overwhelming. Also, part of our job is to tell that client that they may not be guilty of the offence they're charged with, but they may be guilty of another offence, and that is something we would always discuss with the prosecution where appropriate. The other reason why I say I don't represent people who tell me they're guilty is because all lawyers have their first duty to the court. So if a client tells me that he is guilty of an offence, and in fact he then says, please go and get me off and get me found not guilty, I, like every other criminal defence lawyer in this country, cannot do that. It is our first duty and our first responsibility to the court, and any lawyer should not and cannot mislead the court. And if we are found to be misleading the court, then we are at risk of being struck off and ending our career. So whilst our first duty is to the court, our second duty is to defend our client to the best of our abilities. Now, access to criminal defence legal advice is one of the cornerstones of our justice system. We have a justice system that in England and Wales that I'm immensely proud of, and I think generally speaking works. It's under pressure like every government department, and there are two aspects to it that should really give the public faith as to why it's a system that works. One is that you have access to a defence team, you have access to legal advice, and two, you have the right to appeal. And those two things taken together mean, as a public, that generally speaking, in the vast majority of cases, when someone is found guilty in our courts and has not appealed or time for appeal has lapsed, then you can be fairly certain that that conviction is safe. There are obviously some very high profile exceptions to this, but in the vast majority of cases, you can have faith in our system because of the access to legal advice and the ability to appeal. Now, there are three stages where you may come into contact with the criminal justice system. The first stage is obviously the police station. Now, if you find yourself being arrested or being invited in for a voluntary interview with the police, you have the same rights, and one of those rights is access to free and independent legal advice. Now, the key here is the word free, and the other key is the word independent. Yes, as defence solicitors, we have nothing to do with the police, and we are completely independent from their inquiry, and yes, we are free to you. The government pays us through legal aid to attend a police station, whether remotely during this coronavirus breakdown or in person when times are a little bit normal. And with that in mind, if you find yourself being interviewed at the police station, whether as a voluntary attender or under arrest, ask for a solicitor. It's free. I can see no good reason why you wouldn't have a solicitor. Even if you're saying, well, I did nothing wrong, I don't need a solicitor. Well, there's a very good chance you'll still need a solicitor. Or, I've been caught bang to rights, I don't need the solicitor. Once again, there's a very good reason why you might need a solicitor, and in both cases, you may not fully understand the implications of what the police are investigating and how far the police investigation may go. So given that it's free and it's available to you 24 hours a day, 7 days a week, 365 days a year, use it. And please ask for a solicitor. You can ask for me in person if you wish, or if you don't have any solicitor in your local area that you want to use, you can always ask for the duty solicitor who will be made available to you. The next stage is when you go to the magistrates court. So the magistrates court deals with a series of minor offences like low-level shoplifting, criminal damage and assaults, as well as your drink driving and other motoring matters. It is also the first court that hears cases are more serious that go on to be heard at the Crown Court. If you find yourself in the magistrates court and you're facing a charge that has the potential to carry imprisonment, and then if that's the case, and that, for example, would include drink driving, then you can always ask for a duty solicitor at court, or once again, you can arrange to have a solicitor there for you in advance, and you can contact me if you wanted me to be there for you, and we could represent you at that hearing. Legal aid is available for magistrates court hearings, but it is limited to a two-stage test. The case has to be serious enough, so if you're in court for, say, speeding, it's extremely unlikely you get legal aid. It's almost certain you won't, because it's not that serious a case, unless there is something very specific about you that means you need legal support. And the second stage is to do an assessment as to your means. So in other words, if you can afford to pay for your own legal representation, then the government's legal aid policy is that you should pay for your own. But if you're on benefits or if you have limited income, then please contact me and we can make an application for legal aid to see if you qualify. The final stage of any criminal proceedings, or the most serious stage of any criminal proceedings I want to discuss, is the Crown Court. If you are charged with a far more serious offence, such as GBH or murder, or a whole list of other very serious offences, including rape and a series of other sexual assaults, then the Crown Court is almost certainly where your trial will be held in front of a jury. Everyone qualifies for legal aid in the Crown Court, but the Crown Court, once again, has a means test, which means you may have to contribute either from your savings or your capital, including the value of your home, towards your legal aid, or indeed from your income. But once again, if you have a Crown Court case that we can assist with, then please get in touch. We'll submit a legal aid application for you and represent you at the Crown Court. And your representation at the Crown Court will almost certainly involve someone like myself, a solicitor, and in many cases a barrister as well, to help present your case in the best available way. That is my quick scamper through the criminal justice system and your access to legal aid and access to legal services. If you have any questions or queries, please do not hesitate to contact me. As always, this is a little bit of legal guidance as opposed to legal advice. Any legal advice you want on a matter, please contact me and I'll apply my knowledge, my experience to the facts of your case. But thank you for listening.